Hey, Rob, we're just waiting for Will, so just bear with us.
Hello.
Hey, right, Will, you all right?
Yes, thanks. Yeah.
Cool. Let's just do the usual blurb and we'll get straight into it because we've got some interesting questions that have come in through the comments in the YouTube channel this week. So welcome, everyone. Usual business. This isn't legal advice. We're doing our best and hopefully we'll provide some useful information. But it's not that sort of relationship where you can sue us if we get something wrong. If you haven't already, please do subscribe to the channel. There's a little red arrow down the bottom of the screen. You should be able to see, just click on that, subscribe just to see more of this. And if you feel like it, if this is a good video in the end, just feel like it, whatever. Now, when it comes to asking questions, so the live chat that you guys can see in the live stream won't be visible afterwards. So that's just partly just to kind of minimize the amount of data that's rumbling around, but just to kind of minimize personal data further, if you just ask questions as if they're about someone else, it just kind of keeps everyone a little bit safer, really, I guess is one way of seeing it. I think that's everything. So yeah, cool. Will, we've got five questions that have come in through the week, and I assume we'll see some coming through the live chat at some point. Can we start with
Sorry.
Oh, you're right. Oh, yeah, I think Will's just occupied. So yeah, I think if we start with question 2, Will, because it's a nice easy one, and then we'll kind of work our way through them to get to the more interesting ones, basically. So the question is, and just for the purposes of the recording, this is question 1. So my prevention duty is nearing the 56-day period, or the end of the 56-day period. Will I be owed the relief duty even if I'm not homeless? So this is pretty straightforward one, really. You can make a homeless application if you're likely to be homeless in the next 56 days. And if you make a homeless application at that point, the prevention duty will kick in. So you still get the personalised housing plan. I assume you still get the assessment of housing needs. Actually, don't know that bit.
You get that with the relief duty, but not the prevention duty.
Okay, cool.
If I'm not mistaken.
Yeah, no, I think you might be right. Yeah, so but you do get a PHP, and yeah, so essentially that should be, I mean, in the real world, that's maybe the housing officer trying to ring up your landlord to see if they're serious about the eviction and whether the landlord might hold off. There's not a huge amount else the housing officer can do other than get you up and running on the housing register. But basically, the prevention duty can just keep rolling on. The relief duty can keep rolling on as well in some circumstances, but the prevention duty will keep rolling on, provided you remain threatened with homelessness. So if you become homeless, it immediately kicks. The relief duty kicks in, and if the landlord agrees to keep you on, for 6 months or whatever, then the prevention duty would kind of expire or end at that point because you're no longer threatened with homelessness. So, as I say, I haven't got anything else to say about that. Will, have you got anything else to add into that? Seems to be pretty open and shut.
No, that I haven't got anything to add to that.
Okay, cool. Right, that's that one done. Excellent. So that's one done. Number 2.
That was number 2, wasn't it?
Yeah,
I've got number 1 as a session.
We'll come back to number 1. I'm just doing it. Yeah, so actually, Will, you weren't here last week. So basically, what I'm trying to do is have like a index of questions that go into the recording. So if I get organised, I'll write the questions onto the the comment section or whatever, so people can kind of just dive into the bit they're interested in. So yeah, on our list it's question 3, but the second question for us tonight is, will it be a few more weeks or could it be months for section 190? Obviously it's a little bit of a sparse question, but I think we can work out what that's about. Section 190 of the Housing Act is the duty to house people who are in priority need, but they have been found to be intentionally homeless. Now, I remember when I worked at Bedford Borough Council 10 years ago, I was amazed when I found out that there was a housing duty for people who were intentionally homeless, because I'd always been told there wasn't one. So when I kind of read through a textbook at the end of my time there and kind of thought, all this amazing stuff that was kind of conveniently left out of the stuff I got told when I worked there. So yeah, if you're in priority needs, you are owed the Section 190 housing duty, which is the duty to provide, and I'm just going to read. In fact, what I'm going to do is I'm going to just see if I can just share the screen very briefly so you can see it in the Homelessness Code of Guidance. So if I'm organised, it's 15.15. I'm not organised. Hold on, let me scroll down to it. or 15.13 or something. Yeah, here we go. So yeah, I mean, I'm not going to leave it up there for too long, but you can see there there's a few paragraphs which are relevant. So basically, the wording is that the housing authority must secure accommodation for a period of time that will provide a reasonable opportunity for them to find their own accommodation. And this is interesting. I worked on a case about 6 or 7 years ago where this kicked in, and we were able to extend the person's stay in Section 190 accommodation. I'd be really interested to see if there's any case law on this. There was case law, as I say, when I was reading up it back at the time. But if you think about it these days, because the housing crisis is so bad, I'd be very interested to see what a council decides is a reasonable, or give a period of time that gives you a reasonable opportunity to find alternative accommodation. Because if you think about how stuffed people are, you know, how it's clear the council has to house you for a period of time that actually gives you a realistic chance. And if you're, if you've got multiple support needs or something, I remember I worked with a guy who he'd already been barred from all the support accommodation in the town. He had no money, and so it was going to take him longer to find accommodation. And that was my argument. That was why they extended the stay in temporary accommodation. But that's what the law says. I remember reading case law a long time ago, which basically said it's not the same thing as having an indefinite duty to house people. So, you know, the local authority doesn't have to kind of house you for 6 months because that's kind of what you say it will take to get housed. But there is a lot of wiggle room there. And I know that, a lot of councils will just have a blanket, 14 days, or I don't know, I guess in London it might be 7 days or something ridiculous. That they're saying that gives you a genuine opportunity to find alternative accommodation. So yeah, so in one sense, if you're being housed under Section 190, as in you've been found to be in priority need but you're not intentionally homeless, first thing, if you've got kids, you should be referred over to Children's Services. But whatever your circumstances are, they need to look into your details of your situation to work out what period of time you really need. And if you're single homeless, it might be at that point, that's when you're going to be applying to support accommodation like mad to try and get somewhere. Maybe you've already been doing that and kind of on a waiting list or something. But that's so for a single homeless person, it wouldn't take very long, I would have thought, to get somewhere. But for some people, it will be because of their particular, support needs, disabilities, whatever. So yeah, Will, anything of this?
Yeah, well, if I could add, Section 190 is something I've been dealing with for very many years now. That's not to make out that I'm a sort of world authority on it, but I've been aware of, when I first came across it, which I think I'm horrified to say was before 2002, when it was beefed up a bit. And the original idea was that they had a duty to advise and assist you, and they would discharge that duty by saying, you've had plenty of time to find somewhere because it's taken us a while to find you intentionally homeless. And during that time, you've had lots of time to look, even though until they found they might house you. So you probably weren't looking for your own accommodation. So then in 2002, they added a bit in there. So you couldn't just give them a list of landlords and best wishes. You had to actually carry out an assessment of their housing needs. Now, that may sound familiar to the thing I go on and on about every week, which is the Section 189 duty, which came in 15 years later with the Homelessness Reduction Act. So in 2002, they said, before you can give that advice and assistance, you have to actually assess their needs. But in practice, that tended to be them just saying, you've had plenty of time to look for somewhere, and same thing. Now then, the Homelessness Reduction Act adds the provision of a detailed housing needs assessment, which is a much more serious enterprise than just sort of doing a notional one. So they have to assess your needs. Now, the problem, as I find it for the councils, obviously the courts are not going to get too involved unless if the council say, we think you had a reasonable opportunity to find somewhere. The problem is that if they think that, then the council ought to be able to identify somewhere themselves. Because if the person says, well, I haven't found anywhere, can you tell me where there is somewhere? And they say, no, but we think you've got a reasonable opportunity. It starts getting irrational because they're saying, we know something, but we're not going to tell you. And the truth is they probably don't know it. Now, the other thing that's so what I would say, to go back to the question, is it going to be months? I mean, it could be. I mean, the local authority's starting position will be, no, we're just going to give you a very short time because we think you should find somewhere yourself. And the starting point is obviously you're not entitled to be housed because we found you intentionally homeless. And for years, that has basically meant the game over. So then the thing to bear in mind is that many of the people who are looking at Section 190 have children. And that's the reason why they're in priority need. It's slightly more difficult for single homeless people, and they would just have to rely on the fact that the council hadn't assessed their needs properly and see if they could find fault that way. But if you're looking at a Children Act, if you've got children, then the local authority are under a parallel duty to assist you under Section 17 of the Children Act. Because if your children are facing homelessness because you're intentionally homeless, then they're in need, and the children's services have a duty to assist you, which they will resist as much as they can till they their initial thought is, no, sorry, there's no parenting, there's no risk to the child from the parents, so there's no role for children's services here. You need to talk to the housing department. And I've had this case that I've just been dealing with on a local authority in London, where we've got a dual Children Act Section 190. And believe it or not, the children, I mean, you couldn't, I mean, I hate to use this expression, but you couldn't really make that up. That what the children's services said to somebody who lives in Bexley was, we're going to give you assistance. We'll give you a flat in Manchester for a month. And there's a twofold negative to that. One is, I mean, not that I've got anything against Manchester, but if you live in Bexley and your children are at school in Bexley, you don't really want to go to Manchester just because the council offer you that. So number one was it was almost like saying, here's something that you don't want and we'll offer it to you just to be nasty. But then the idea was that you'll give it you for a month, but there was no suggestion they would help them find anywhere, or even that they believe they would find somewhere, unless there's a sort of implicit assumption that once you get north of Watford, there's loads of accommodation going, which isn't true. So we've judicially reviewed them and said, you haven't come up with any proposals, and it'll be interesting to see what happens. But so long and short of it is, I think they could be months. And if they say, well, we're going to kick you out, and they've got children, then you'd be in a very strong position to challenge that legally, because they'd effectively be saying your children can sleep on the streets because of mistakes that their parents made. If you're a single homeless a single person with no children, I think you've still got a good chance, but you'd need to get hold of or be seen to be asking for that housing needs assessment. And they would need to identify in that, I think, that they could show that you have got a reasonable, that you can find somewhere. And if you can't, I think it could be longer. There isn't really any case law to go back. I was looking while you were talking, just said there was a case called Conville and Richmond in 2006, but that held little more than, it was for the local authority to make its mind up, but subject to monitoring and supervision by the court, which is true of anything. So I would say it could be a long time, and it should be a long time if necessary to find somewhere. And don't think of Section 190 gets stronger every year as a safety net, and people should treat it as one rather than what it was 10, 20 years ago, which was just a sort of very, very paper thin safety net, which you just fall straight through.
And presumably in that Bexley example, they were hoping that by moving them to Manchester for a month, they would immediately become Manchester Children's Services problem. And it's just, on that kind of note, there are other ways that local authorities do that kind of, play warfare with their most complex clients, who cost them the most money. But if it was me in that situation, I'd probably give Manchester a heads up and say, do you know that Bexley's doing this? Not that they've got any power to do anything, but they can get an angry phone call from the chief exec or something, which might do something. But that sort of like just passing people out of your local authority shouldn't be happening. Obviously it does. And I don't know if it's it's not technically illegal, but it's something that would, you know, raise with politicians or whatever, say actually that's clearly like not promoting the well-being of the kids just to behave like that. I did have another thought just as you were talking, where you just reminded me about something, but I've probably now forgotten it. So yeah, it might come back to me. That's cool. Yeah. Okay. So yeah. So basically, yeah. The way to deal with it is to make sure you're getting your records and you're getting a copy of the assessment, and you're just making sure that it's actually, you know, a realistic kind of thing that they're actually asking you to do. Got a question just come in. I think it's a question. It might be a comment actually on the chat. So someone who's applied for temporary accommodation in London, how long does it take from your application getting processed to you getting temporary accommodation? So good question. Happens a lot. The key thing is with this is that the council's threshold or the council's duty to put you into temporary accommodation or interim accommodation, there is a little bit difference in that terminology, but don't worry about it. Basically, it's triggered the moment the council has reason to believe that you might be homeless, might be eligible. That means basically having recourse to public funds, and you might be in priority need. At that moment, the duty's immediate. So in one sense, if you rang the council up in the middle of the night and you satisfied those three criteria, then the council would have an immediate duty to house you. Now, councils don't a lot of the time, and Will made a really good point a few weeks back saying it's all very well to know the council's breaking the law, but how can you get them to follow the law? And unless you can get a solicitor, it's actually very difficult to get any sort of timely response. You can go down the complaint route. You can get, you know, involve councillors, whatever, but that might just result in you getting a complaint rolling on for a year and then it going to the LGO, and yeah, they might uphold it. But by that stage, you've probably forgotten about it. You're probably dealing with the next issue that's come along. So yeah, again, if you look, I think it's 15.4 of the Homelessness Code of Guidance. So anyone, obviously, you could just Google Homelessness Code of Guidance. I think it's 15.4. I'm just going to double check to make sure I'm not misleading you. Yeah, it is. Yeah. So 15.4 of the Homelessness Code of Guidance basically just states that criteria, and there is there's a really good video on this channel which involved Jan Luber, Sarah Steinhardt, and Ara Taylor, who are all judges, and they talked about that section 1, particularly section 184, but section 188 a little bit as well, just to kind of hammer home the point that it's an immediate duty. So you might just want to seek that one out. I think it's called 3 Judges Talk About Section 184, something like that. Just have a look on the channel just for some proper heavyweights. They're written textbooks and stuff. So yeah. This nagging me now because I had a good thought about the section 190 question, but as I say, we might come up with the next one because it's also a related question, the next one that we had come in. So again, seems like a really obscure one, but this is another really cool thing about homelessness law. So I've been in section 108 interim accommodation for 4 months. I received a minded 2 letter that they find me intentionally homeless due to arrears at my last settled accommodation. But I will still be served a section 190 as I'm in priority need. Blah blah blah. So how long will I be in interim accommodation? We kind of answered that. It might be the same person actually, but this is the important bit. So my mum is a single mother, and I have a younger brother who's 17. It's been hard to find private accommodation due to income. So this question would suggest, and this is why I like housing law, because you can often find a little nugget of goodness in these situations. So the way this question's phrased would suggest that there are two children of the single mother, one of which is 17, so is a dependent child, one of which is now an adult. And basically the Homelessness Code of Guidance, housing law, but the Homelessness Code of Guidance makes the point that there's no such thing as an intentionally homeless family. It's, the mother in this case, if she's made the application, if she was to be found intentionally homeless, there's nothing barring the adult son from making a homelessness application as well, and potentially even the 17-year-old. I've never tried that one, but I've used this little. It's not a loophole, I guess. It's just because the children don't deserve to be homeless. If it was the mother's tenancy, then it was her job to pay the rent. And we'll come back to kind of whether she actually isn't a James in a minute. But if I just go back to, I just find it. So yeah, 9.10 of the Code of Guidance, and I'll just pop that up on the screen as well. Again, you just pause it and look at it in your own time. But basically, it's just kind of lays this principle out, and it's a really useful one. So let me just hold on a sec, share the screen. So share screen, there we go. So it's that one in the middle, 9.10. I might as well read out a bit. So where a housing authority has found an applicant to be homeless intentionally, nothing in the 1996 Act, that's the Housing Act that kind of, we're talking about here, prevents another member of their household from making a separate application. So yeah, basically it's a situation may arise where one or more members of a household found to be intentionally homeless are not responsible for the actions or omissions that led to the homelessness. For example, a person may have deliberately failed to pay rent or defaulted on the mortgage payments, which resulted in homelessness against the wishes or without the knowledge of their partner, or potentially of their child, of their adult child. So I would say that opens up this option of if this family were to be found intentionally homeless, then the adult child could make, that's weird oxymoron, but it's grammatic. Yeah, the adult child, the child of the single mother who's an adult, can make a fresh homelessness application. Now, this is where we go off in several different directions. So the first thing I'd be looking at here is that often just because you have rent arrears does not mean you're intentionally homeless. So you really need to pick apart that minded to letter. Now, again, it's a bit of jargon. A minded to letter is where in the inquiry process, the council's kind of made quite a lot of inquiries. They're forming a decision about something. It might be that you're not in priority need, or it might be you are intentionally homeless. They have to essentially write to the applicant. I think it has to be in writing. I don't quote me on that. They have to give the applicant an opportunity to discuss the situation before they then go and make the final decision. So at the minded to stage, you've generally got like 7 or 10 days to respond. And you really, really, really want to be picking apart that letter. And the key thing with this is going to be, was that rent affordable? So again, Homelessness Code of Guidance 9.7, intentional homelessness, basically to be genuinely intentionally homeless, you have to satisfy 3 criteria. It has to be all 3, and that's the key thing. So one is you've deliberately done or failed to do something that's led you to become homeless. So that may be failing to pay the rent. The accommodation was available for you, which in this case it would have been. But the third one, crucially, is the accommodation must have been reasonable to continue to occupy. And if your accommodation is unaffordable because the rent is, I don't know, whatever, £1,200 a month, and your income just simply won't cover that, plus all your essentials of life, your food and all that sort of stuff, then you cannot therefore be intentionally homeless. So loads and loads of people who are found intentionally homeless because of arrears are not intentionally homeless. And this, I've now remembered what I was chatting to, that was nagging me a minute ago. And if I try and just hold the thoughts for a second, so in that the previous case about the section, it's gone again. I had it. Will honestly, it's going to come back again. But
if it comes back, stop what you're saying. And
it'll come because it's somewhere in there. Basically, you want to be challenging that intentional decision. Essentially, you want to be making sure it's legit. I'm going to try and think what it is. Will, do you want to just kind of fill anything in that I've missed out, or any other thoughts that we've got here? So I think there's some other things that would be interesting.
Here's some thoughts, just working sort of backwards. The key thing to note, we don't know quite, unless I've missed it, I don't know why the person was found is considered to be intentionally homeless. But so it sounds as, because they say they find me intentionally homeless, so that suggests that this person is the applicant and that their mother and younger brother are part of their household. Does that sound right to you?
So it's possible it's just lost in translation a little bit, but potentially, that could be one of the situations.
So as you say, anyone else in the house. So we don't know that. Presumably, if it's usually the case, unless you're a couple, they can sort of say, well, you both, just because your husband didn't pay the rent, you knew that he wasn't paying the rent, you could have done something about it. There is case law on he was gambling it all away and she didn't know about it, or the other way around. But let's assume that
there was a it's not a funny case, but it was the way the judge said it. Basically, exactly that had happened. So the husband had been gambling it away. She found out about it, and that was the wording of the judgment. The judgment said clearly the fact that she'd gone and got so outraged by his behaviour. This was before domestic. This was like early 90s. This was kind of before the kind of prevalence of that understanding. But that was kind of seen to be evidence that she had not acquiesced in his actions to not pay the rent. But as I say, it's kind of just the wording of that case was interesting.
So I would say yes, if assuming that the intentional act is only an act by one member of the household, which isn't sort of, the others aren't to blame for as well, especially the 17-year-old. But the thing I'd warn there is that if the brother is 17, then there's every reason to act very quickly to make that second application, because it sounds like there's a danger that once he turns 18, there won't be any priority need.
But so on that point, and again, I'd have to really kind of go into the detail on this. So I think somewhere in it, weirdly, you're in priority need if there is a child who's dependent on the applicant. I might just need to check that out. Just the wording's quite unusual. The way I got around it in one of the cases I worked with was basically pretty much exactly this. You know, there was a adult son. He was like 20 or something, and his mum was quite unwell. And he was driving the kids to school. He was kind of getting the shopping and all that sort of stuff. And so in that case, that they were seen to be dependent on him as well, even though he was a sibling. But I'm sure, yeah, I probably haven't got time to do it whilst multitasking. But I think as I say, it's a bit of an interesting kind of thing around automatic priority need through having dependent children. In that it's not enough just to have.
If this is a genuine, I mean, in this case, it sounds like the 17-year-old is a family member, so it's not like they've sort of borrowed a kid and gone to the council.
Because there was a case on this kind of point where there was a husband and wife. The wife was 17, and she was, and they made the argument where, well, she's a dependent child. And it's like, no, she's married. She's not dependent. She's not dependent on that. I think that's where it kind of, as I say, it's really obscure, but it's in there. So yeah, so potentially I don't know if I ain't got time to find it right now because it's a real.
There is a little stream of cases that goes back to that deals with this issue, and I've forgotten what it is. But let's assume that fun as it would be to discuss that, that I'm just warning that if the members of the household don't have any medical conditions that would make them vulnerable, they've got to act quickly, because if the brother was 17. Turned 17 last week, great, but if he turns 18 next week, beware, because you won't have. And the beauty of it is just get the application in, because then it's at the date of the application. They can't say, oh well, you were 17 when you applied, or your brother was 17 when you applied, but now he's 18. It's the date, because otherwise it's the date of the application, because otherwise they've got an incentive to drag things out. Which is not allowed. So that's what I would say.
The niggling thought I had was it's kind of relevant to these two, is that, and we said it before, but it's when children's services get referrals from housing, and as you said, Will, like they're very reluctant to kind of to actually do anything. If they were sensible and were boxing smart, they would get very kind of savvy with the law around intentional homelessness, because, as I say, loads of people are told they're intentionally homeless when legally they're not. And if a social worker actually looked at the decision when someone's referred to them, they could probably pick apart the decision within that 21-day period that you've got to actually challenge it, and probably, just essentially legitimately and in a way that benefits the family, push them back to housing and just show the housing that they're actually not intentionally homeless. But yeah, I've said it before, I keep going on about it. Social workers don't appear to have any training on housing law in general, certainly within the degree course they do, which seems to me to be crazy, but because they're dealing with lots of people who've got housing needs.
Plus, I take it a step further that that they're under pressure from management to not rock the boat in terms of the housing department. So if what you're suggesting is if they sort of got their textbooks out and studied intentional homelessness, they could help the person challenge it, then I think they probably get an email or a knock on the door from somebody in management saying, what's this about you helping people overturn intentional homeless decisions? Of course, the other one is what they could do if they're being sensible when they're doing the Section 1, when the person makes a Section 190 application and they do a Children Act assessment parallel to that. If they're being sort of fair about it or realistic, they do an assessment saying, yeah, the children are in need. It's very, very difficult to find accommodation. We think it's almost impossible they'll find any without assistance from the council. And then then if the housing department tried to say, well, you've had plenty of time, it's easy, the applicants would rely on the children's services, which is precisely why children's services won't do it. Sometimes
that's interesting, because in my experience, social services have no qualms about, they'll get into full-on arguments with like their equivalent in housing. And again, when you've got two-tier councils as well, where you've got social services under one roof, I'd be surprised if there's that much pushback from it. I'm sure there's other retaliation they could take or whatever in another way. But as I say, if I was a social worker and the social workers I know, I think they would be really kind of sensible to get a hold of these kind of like the intricacies of intentional homelessness. But yeah, okay. Anything else we want to add to that at all?
Well, we didn't really answer the question about section, because there's a section 190 question in this one as well, but we sort of dealt with that, didn't we?
Yeah. So in terms of how long it would be, well, yeah, I think we dealt with that in the previous one. As I say, it might even be the same person who's asked questions on different things. I don't know, but yes, yeah. But as I say, I think yeah, the going back to the kind of the very basic response to this is, one is get your head around the minded to letter and actually see if it's accurate, and see, and generally see, well, was it affordable? We've done other videos about that. I think there's a again on my channel, there's a video fairly recently about affordability, or it includes affordability. So I think it's the video is called Intentional Homelessness Explained or something like that. So you can kind of do some maths. There's some kind of figures out there that you can kind of research up on and see you can show the council actually didn't have enough money. Certainly for anyone who's dependent on benefits and is got to top up with a rent in terms of private rented, then they're almost always going to be in unaffordable accommodation, because the idea is that universal credit, the living out expense bit, is supposed to be for your living expenses. It's not supposed to be for housing. That has, it's got a bit more complicated with BAPT in that case, but anyway, I think it's still roughly the same. Cool. So that was question 3 for the live stream. Well, the question that we've got down as number 5, I suggest we leave that till the end, because it's one which, is a bit more bit murky. So let's go back to the first one for us then, Will. So this is question 4 for the stream. So I've got a section 21, and my current property is no longer affordable due to rent increase. Any advice you can give me to this query, please? I've suggested temporary accommodation with the council. The caseworker responded suggesting temporary accommodation could be even higher to my current rent. So whatever the situation was before, this person, there's been a rent increase, they can no longer afford the rent. So we've just been saying it's no longer reasonable to continue to occupy the accommodation. So they're at liberty to make an application now, and the relief duty should kick in. That's something that housing officers often miss. They're not threatened with homelessness because of the section 21. They already are homeless because they cannot afford the rent, assuming that they genuinely can't afford it. Now, the kind of the advice or the response they've had from the housing officer that temporary accommodation is even more expensive, that is not likely to be true, or it might be true, but that's not the applicant's problem. When councils offer any type of accommodation, it has to be affordable, and so it might be that they're putting them up in a Premier Inn or something, and 60 quid a night or something, but they don't have to cover all that. There'll be some sort of means test in terms of what they can actually afford, and so they have enough money to pay for their food and whatnot, and the council would effectively have to subsidise it. Now, again, I worked with a case where a guy, he jointly owned his home. It's a complicated situation. Council had a duty to put him in temporary accommodation, but because he owned half a home, he couldn't get housing benefit for the temporary accommodation. And in that situation, what it meant was the council had to offer the temporary accommodation at a peppercorn rent, so it's like £1 a month or something. So because any accommodation they have has to be suitable. So what else, Will? I mean, I guess there's some other kind of potential kind of things to say here.
I go along with you. I was just looking up the law, just to quote it, because some people listening or watching might be thinking, what are they on about? If you've got a home, how come you're homeless? And the point about not being able to afford the rent brings in what is section 175 of the Housing Act 1996, which defines what is homeless. And it says, in order to be homeless, you only have to not have accommodation, which is reasonable for you to continue to occupy. So it's arguable that if you can't afford to pay the rent and you're only going to run up debts, it's not reasonable to continue to occupy. So that's why it is. It's got to be reasonable. Sorry if you'd made that point, Mike. I just thought
no. I think it's so many people miss it. So many housing officers miss that.
No.
We talked before about, I can't remember what the LJ case was, where they specifically, that was the mistake the council made, was that this person was already homeless because they already couldn't afford their rent, and they were not threatened with homelessness when they got evicted down the line or whatever. They were already homeless. They should have already been treated as a homeless person, and as I say, that meant the relief duty kicking in. And it's not that they're immediately going to get whisked off into temporary accommodation. Often what councils will do is they get a DHP through a discretionary housing payment to increase that person's income so that they're no longer homeless, and then in theory everyone wins until 3 months later when the DHP runs out and they've got to come back again. But that's so in one sense, the kind of actually going back to the question though, suggesting temporary accommodation, it's unlikely the council is going to put you in temporary accommodation in that situation. They're most likely going to, well, in this situation, they might do nothing and just say, well, it's kind of the eviction's happening. There's kind of no real value in paying the landlord right now. They might kind of take that sort of view. I don't know if that's legit or not, but they often say that sort of thing. Well, that those kind of last couple of months. I've even seen housing officers say, well, why did you pay your rent for that last couple of months? Because you knew you're going to get evicted. Why didn't you save that money up to find your move on housing? And I don't think that's a legit thing to say, but it's said. So yeah. So
just following it through in sort of steps to sort of the legality of it. So let's say we've established the person's homeless. What we don't know from this question is whether they're in priority need. And I mean, we can assume that they're not intentionally homeless, but the question would be if obviously if you just ask the housing officer what to do, they'll just say, well, please leave me alone and don't put me under any pressure to give you somewhere to live, because that's the dynamic, because they've only got a certain amount of accommodation. So, but if you say, no, I insist you give me somewhere, or a lawyer writes a letter saying you've got to process a homelessness application here, I think it might be quite difficult to go running off to court and say we want temporary accommodation, like you say, even if they are in priority need, because a judge might say, well, you're not actually sort of street homeless, you're just running up debts. Now, whilst that's not desirable, it's open to the council to maybe make inquiries and see if they can help you avoid the loss of your home. But as you say, there's not much they can do if you can't afford the rent, because they can only give you discretionary housing payments temporarily. So I think they'd have to accept a duty eventually. And if they accept that you're homeless, then it follows that if you're in priority need, there's a 188 duty. So I think what I would be saying to if I was continuing that conversation that the person's having with the caseworker, after they've responded, suggesting that temporary accommodation should be even higher than the rent, could be even higher, I would say, well, obviously that can't be right, because it's got to be suitable accommodation. So it can't be. They can't say we can't house you because we haven't got anything affordable. And equally, they can't say here's some accommodation, but you can't afford it. But that's your fault for applying to us. So I think I would continue the conversation by saying, are you going to process a homelessness application or not? Let's get on with that bit. And are you going to put your decision in writing? And if not, if you're not processing a homelessness application, then challenge that refusal to process the application. And then I guess they could drag it on for a while whilst they're thinking about it, in which case we might be back to complaints, because I think I would have trouble getting a judge to make an order. I mean, maybe I'm being weak on this one, and maybe other people listening will say, of course you can go for it, because the person shouldn't have to run out debts. So maybe you could go for a court order and say, process the application, give them temporary accommodation and stop messing about. But I think I would be inclined to make a complaint if they don't make a decision quickly. And then there might come a point where it's gone on for, like, it depends how much the rent's gone up by, I suppose. If the person's running up massive debts, then you could sort of give it a couple of months and then say to a judge, this is outrageous.
Yeah. So it reminded me of a case that John from Just Us worked on a little while back, but basically a guy, I think he had something like 20k worth of savings or something, went to the council, he was homeless, he was, in priority need, and they said their advice was, you can't get housing benefit, there's nothing we can do. So he basically went, I don't know what circumstances were, he went away, ended up spending his money on hotels and kind of all, that sort of stuff. And when John found out about it, he got him housed again, because by this stage he was like nothing left at all. But then John complained, and basically, I don't know what amount the guy got, but John's complaint was essentially, he should have been told when he first approached. One of the things he should have been told is when his savings drop below 16k, he can claim housing benefit, and therefore they can provide accommodation that way. And as I say, at one point it looked like he was going to get the full, like he was going to get 16k back, but I don't think he did in the end. He got a lesser sum, but kind of that sort of relates to this question, that idea of the advice that should be given by a housing officer around temporary accommodation should be competent, and something that again, housing officers, they really kind of, I've seen housing officers be very kind of defensive about their position of where they just need to go and find private rented, but everyone knows you can't, there isn't enough private rented. So by telling people go and chase after this one or two properties in town that've got affordable rents on them, they kind of know that person just can't, it's not going to be able to do it. It's very unlikely they're going to find something unless they get very lucky. As I say, which is, I haven't got a problem with housing officers saying to go and try and find something, but it's that kind of, that sort of like washing of hands, saying, you all need to go and find it. It's like a bit like, was it Lee Anderson saying you need to shop in the reduced section of Tesco? Well, if everyone does it, there's no reduced section left, is there? We can't all do it. So it's, anyway.
I think there's an element to this which is quite sinister, and it's also a sort of interesting political social issue, which is that at the back of this, the housing officers are sort of banking on the idea that this might end up in front of a judge, and a judge, by definition, unfortunately, you can predict is somebody that probably doesn't have problems with their accommodation. And so, especially in the High Court, sometimes the only housing problem they've had is whether they get their father's old room at Cambridge when they got there. But the judge is likely to say, "Oh, everyone can find temporary accommodation. What's a lot of fuss? Why don't you go out and do something?" And I've heard judges make those sorts of comments, which and there is a sort of type of thinking which barristers try to encourage judges to adopt in this type of case, which is that there's no such thing as poverty, and there's no such thing as shortage. They're just people trying it on, and that's a sort of Lee Anderson type view as well. And somebody's saying to them, "Look, just push it, and we may get away with that." So, I think that's, and also ultimately, I suppose that's their fallback position, isn't it? That why don't you go and find somewhere private? And
it's your own fault if you can't.
Yeah. And as we go back to where we were before with the reasonable period, I mean, if it's so easy to find somewhere private, why don't you give them a list of available private properties and they can go and talk to the landlords?
It'll be possible. I mean, so I think I mentioned this before as well. So the Bureau of Investigative Journalism, which is kind of like a national, they do some really cool stuff. Basically, a few years back, they did research into how many affordable properties are around, and they chose Bedford by random, I think. And so they went on Rightmove. They did the research and kind of for the whole town, there were 2 properties advertised in the course of a certain period of time. There were actually, the local housing allowance would actually cover. Out of so it might have been 2% or something like that. So you could probably, if you're an advocate, you can probably actually do a bit of research and say, we've had a look at accommodation. There is nothing. There's 1 or 2 properties. There isn't anything. And as I say, like that's the housing officer may not be able to do anything about that, but it's not the vulnerable person's job to worry about housing stock and supply. That's the council's job. That's their responsibility to ensure that there's enough housing out there. Or central government, even, I guess, so that somewhere along the line. So yeah, have we covered that one well? I think that was a that's a pretty comprehensive answer. That's cool. Okay. Just a question come in there, as well as some comments, which are cool. So the question is, a single mum with baby will be homeless shortly. Overcrowding issues, worried they'll be placed in a hostel as opposed to own accommodation. Is she worrying needlessly? Sadly, she's not worrying needlessly. It's going to depend on where you are. I would say that if you're in London, almost guarantee you're going to get B&B, hostel type accommodation, shared accommodation, or accommodation with shared facilities or whatever. Outside of London, you know, you may well get something which is self-contained. It's really just about the council, you know, what stock they've got available. So there are some. Again, I need to go back to the notes I've got from Sarah Steinhart's training on Equality Act stuff, but that she I remember her talking about a case where she basically won, where the argument was, you know, you got a newborn baby or whatever. How does the mum go to shower? You know, kids, where do the kids go when she's having a shower down the corridor or whatever? You know, how do they keep them safe? And as I say, I think it was kind of like became an Equality Act issue in terms of protected characteristic and you know, it's something that only affects females or is more likely to affect females. But so there is a, you know, you need a good lawyer basically if you're going to try and make that argument. So, but yeah, sadly, loads of people are put in those kind of places. For, you know, one question I saw recently, someone had been in that sort of place for 2 years now. Councils are supposed to only put you in B&B accommodation if you've got children for a maximum of 6 weeks, unless it's council owned B&Bs, which we talked about before, which is crazy. But so yeah, I think well, I don't know what else to say in terms of that might be reassuring. One of the things you can do now, if you're not quite there yet, is you can make what's called a freedom of information request to the council to ask them what type of accommodation they've got available, what's the waiting times. Shannon, who's off doing some cool stuff tonight, so she's not here, but she's been doing some really interesting FOIs all around the country around stuff like that, you know, waiting times, you know, how disabilities are dealt with by temporary accommodation, all those kind of things. You can find out a lot of information. It takes 20 working days, so it takes a month, but it's usually readily available. The council can tell you quite quickly what's actually available for people. So yeah, I don't know. Well, as I say, sadly, I don't think we can reassure someone in that situation. It's
no, I mean, I suppose just to sort of be slightly less than 100% negative, I would say that you can, if they put you in a hostel or B&B which isn't owned by the council, you should only be there for 6 weeks. So I mean that's, I mean, if we said if you're in Redbridge, I think it is quite likely you'll find yourself that the landlord is the council. Whereas not all that many councils run their own B&Bs.
Yeah.
But be careful, check who the owner is, and if it isn't, then keep an eye on your calendar. And once you've been there for more than 6 weeks, you could look into challenging it.
Having said that, so the government published a lot of stats online, so they call the live tables, and I did a bit of playing around with because the councils have to submit how many families are in B&Bs and how many families are in B&Bs for more than 6 weeks. And I'm pretty sure Birmingham was the highest. I think they had 400 families in B&Bs for more than 6 weeks. So that's, in theory, that should be something that never ever happens. But there's 400 of them. So if each of them made a complaint and went through to the LGO, they would all get compensation, and maybe that would focus Birmingham's mind, given that Birmingham's bankrupt or whatever it is right now. But and again, I think there was Tower Hamlets, I think, had about 190 or something families in that situation. Yeah. So if as Will says, you know, look at the calendar. As soon as you're on that past that 6 weeks, complain as loudly as you possibly can. You will get treated better. That's the sad reality of this, is that, you know, if you complain effectively, as in you write about stuff and you're raising valid issues, you'll get a better service. And I know that has some real kind of negative side to it as well. But I guess if I was homeless, I'd be wanting to get the best service for me and my family. You know, that's not an an unjust thing to do. It's the system. It's the system that needs to sort itself out. So yeah. hopefully it's an answer. We apologise that it couldn't be more reassuring, really. I think there are some maybe some things just to throw in here that might just be helpful. So one of the things that could happen if you go into London is you get placed a long way away, but that's something that you can challenge as well. If you've got a solicitor, in terms of support network and stuff. But if you have got a support network somewhere, then really I'd suggest really kind of making that point when you're going through the assessment process with the council, spelling out what support you need. If you've got any additional issues, like maybe like mental health diagnoses or something like that, the council should be sensitive to it all. We talked at length, and we did a video, me and Will did, about there's a case with AB v Lambeth, AB something or other, Blessed Lambeth, and kind of that case was all about how the individual, how the lawyers supporting the individual picked apart the assessment of their needs and won the case that way. So I wish that person all the best. Basically, it could be a rough ride. And call on any family and friends you've got to help you out whilst you're there, because that's going to be a difficult period for sure. It's crazy that people, new mothers are put in that situation. Yeah. Okay. So next question, unless I missed one. So thinking about triggering part 7, most likely will be put on auto bid. I mean, Leicester City, just wondering, do you know how auto bid work? Are you able to remove bids? So we can't answer this for Leicester because every area is different. Auto bid, just fill in the jargon for people who are kind of not aware. So if you make a part 6 application, you might, as in you make a housing registry application directly to the council through their website normally, and you're not homeless, you may well get quite high banding. You might get band B or band 2 or whatever. If you're homeless though, you might be homeless, the council should pick that up as a part 7 as a homelessness application. So that's what this question's about. It's about, they're probably under part 6. They're saying, well, actually, I'm technically homeless right now. Should I remind the council, or should I draw the council's attention to the fact that I'm currently homeless and therefore should be treated under part 7? The plus side of that is you get temporary accommodation, or if there's reasons to believe you might be homeless, might be eligible, might be in priority needs. As good as temporary accommodation is, obviously that's a lottery. One of the bad things of doing that, in fact, it's pretty much the only bad part of reasons to go down part 7, is when you get banded, when you get back onto the housing register at the end of that process, if you don't bid on every suitable property every bidding round, the council can lose patience with you and just stick you anywhere. As I say, we just don't know how Leicester's system works. They some councils are more lax. Some councils forget people in temporary accommodation altogether, and because they're staffing and so kind of like haphazard. But I don't think there would be any guarantee really to take yourself off auto bid unless you can show that the property they're putting you into is unsuitable, and that's quite a high threshold. If you've got disabilities, or if you've got kind of obvious issues like you're a wheelchair user and it's not wheelchair accessible, then that would be an easy one to win. Or if it's unaffordable, but many people ultimately will get stuck somewhere that they would rather not be. And again, that's that's the reality right now of making homeless applications. And again, if you complain effectively, if you raise your case effectively, then you'll get a better service. There was one individual, I still see them around Bedford. I stopped working at Just Us 6 months ago now, pretty much. But the council went over and above what they should have done, because every time they weren't happy, the person emailed the mayor and caused a fuss. And I was amazed that the council kind of went with it. I was like, why are you doing this? But they did it, and that person's still in really nice TA. So again, that's the reality of it already. Anything else on that? Well, auto bids, I guess you don't really see that side of things.
I don't really. I mean, I tend to think auto bid sounds quite good in the sense that you would get an offer of council accommodation or social housing, rather than a lot of people I get inquiries from is I can't seem to bid for anything, or nothing happens, so I never get offered anything. But the downside is, I guess, you might get offered something you don't want. I haven't got anything to add to that, really.
Yeah, I mean, so again, it's just dependent on the council. So Bedford would have so-called hard to let properties that no one wanted. And if if you're stuck on auto bid, you get one of those properties. If you want, one of the kind of blocks of town that no one wants to be in. So as I say, unless you've got a legitimate reason it's not suitable, then you're going to have a struggle. And again, this is just my experience at Bedford. The officers have full access to that system, and they'll be able to see if people were making reasonable bids or not. So if they're just bidding on things which are either they're definitely going to lose because there's 100 people on the list, then they would see that as being unreasonable bidding as well. So if there's like one property that's got no one on there, no one bidding for it, you would be expected to bid on that property. You're expected to bid to get housed as quickly as possible. But unfortunately we can't. We don't know what Leicester's system's like. But certainly, again, it's something you can ask them before you go into it. There's no harm in kind of asking the question, how does the auto bid system work? You can have like a what if conversation with them. They're not going to, they're probably not going to grab your hand off and take you under Part 7 unless you really insist anyway. So they're probably quite happy with you staying under Part 6. Cool. Okay, so next question based on B&B. Is there anything to stop a local authority simply moving someone from one B&B to another every 6 weeks and getting around that rule? So I don't think, well, they might do, but legally I don't think they can. No, as we said before, there's a weird kind of exemption where if the council owns the B&B, and it is a B&B, it's for all intents and purposes is a B&B, then they can house them indefinitely in that. So we'll just mention Redbridge before. They've got a block of, I'm assuming it's a block of flats, or block of hostel, whatever. But I think there's the way the Homelessness Code of Guidance is worded. There's nothing that says it's one single B&B. It's just B&B accommodation altogether, and it's quite again in those early kind of weeks of making a homes application, you will probably be moved quite a lot. It's not unusual to have to kind of wait till 5 p.m. every day to find out where you're going to be that night, and then you don't get the call, so you then got to chase the out of hours team and say, where am I? It's incredibly stressful, and it turns out you're in the same address you were last night. But that's again kind of part of the way the system works for people. I don't know. Have you got a different answer to that one, Will, in terms of moving people?
I think that's right. I've never heard of a council trying that, and I think that they would fail because the wording says you can't put people in B&B type accommodation for more than 6 weeks. It doesn't say a B&B type accommodation, and I think it would be seen as a sort of bad faith attempt to get around the law. So no, I would say they shouldn't get away with that.
Yeah, okay. So we're 30 seconds in the future for the people watching this. So we'll give you a bit of time, but unless there's some more questions coming in the next sort of minute or so, we'll call it a night. So we're coming up to the hour. So but I'll just pad it for a minute because, as I say, no one's heard this yet. It's in the past or in the future, or whatever. Whilst you're waiting, homelessness law training. Me and Shannon deliver it regularly online and in person. We're kind of getting around the country now. COVID's sort of well out of the way now. So it's 30 quid if you're an individual coming on your own steam, or it's 50 quid if you're coming from an organisation and they're paying. All full day. We've had literally nothing but 5-star reviews on Trustpilot. So everyone enjoys it. Everyone finds it useful. I think it's fair to say. It's all kind of around what's the legal definition of homelessness, what's the legal definition of priority need, and so on. And kind of all that practical stuff you want if you are trying to help people get housed. So do check us out at Eventbrite. It's usually in the description. We've got another question coming. Good stuff. Okay, so does someone have to consent to homelessness support even if vulnerable? This might be an interesting one because I think I know what this question's about. It might be helpful for that person just to expand on it a little bit, but I'll try and speculate what this question's about, and I'll try and give an answer. And this is really kind of a sweet spot for me because this really pisses me off. Local authorities, when you look at the underlying kind of principles they're working from, certainly my experience, in my opinion, just to caveat that, when you look at these so-called multi-agency approaches that are really support services and that all kind of geared up to getting people the right support at the right time and everything, when you boil that stuff down, you actually find the skeleton for those memorandums of understanding and as terms of reference are they actually come out of antisocial behaviour sector. How do you deal with street drinkers? And so there's this kind of like, it's seen as, or it tries to portray itself as a nice supportive environment or nice support that's available for people. And these professionals in a room that, the person doesn't have access to, then make all these decisions about what support they need and then go and force that option or try and force that option on them. So I've just seen the follow-up question. So this is not what the question was actually about, but that's just me going off on one really. So you've got these kind of so-called support services, and when you really boil it down, they're not really about finding out what that person wants or needs. They're all about trying to get rid of the problem or the visible problem of homelessness. But now that there's a bit more detail, let me try and explain the question a bit more. So someone with suspected mental health issues, but homelessness prevention teams say they won't help unless the person requests it. They have a possession order expired already. Agencies paralysed and say there'll be street homes. Okay, again, I'm going to try and speculate. There's a couple of gaps here, but so in order to make a homeless application, you have to have mental capacity to ask the council for help, and you have to have some kind of understanding of, the fact that this process will work, the fact you're going to have some choice over, things like, where you live, the fact that when you have a tenancy, you have to pay rent, some very basic stuff like that. And if you don't have that level of mental capacity, then potentially, you can't make an application. So in one sense, in answer to that first question, does someone need to consent to making a homeless application? I would say yes, they do. They need to have the mental capacity to positively make some kind of communication to ask for that help with housing. If they don't have that, then it's gonna, as far as I know, and this is well out my area, but as far as I know, what that means would that the Housing Act wouldn't kick in. It would all be dealt with under the Mental Health Act. So that person would be or should be supported by various mental health workers, potentially an AMP, to kind of assess them, and try to support them to make that kind of approach for help, because that's one of the first things I should do. Because me and Will had talked before about councils, as soon as they see a mental health issue, they're like, oh, you don't have mental capacity, you can't make an application. And the fact is, if someone is struggling to demonstrate they've got capacity, the first question for professionals is, how do we help this person with this decision, or how do we help this person with this process to actually be able to do it? But if you've got someone with mental health issues that are so great that person simply can't ask for help, I can't see how they potentially wouldn't be potentially even sectioned. I just don't know this area of law very well. I would have thought that they would have to step in and not allow someone in that situation to kind of be left on the streets. That'd be my understanding. Will, have you got any better answer than me on that one? Are you on mute if you're?
Sorry, I had some background noise going on, so I switched off from it. I was trying to figure out what's between the lines. So they have capacity. Something I've just been added to the comment. They have capacity, so that sort of stopped me in my tracks. That's what I was going to say there. So if the person's got capacity, then we're talking about a Part 7 application, and they have capacity to make that. I'm assuming that's because one of the frustrating things about capacity is that you always get that it's issue specific. So they may have capacity to do one thing, but I'm assuming they've got capacity to make a homelessness application. If they won't consent to an assessment, that's difficult, because an assessment is part of the homeless application process. It may not be a mental health assessment, but we're back to my old friend, the Section 189A assessment of housing need, or also an assessment as to whether you're eligible for housing or you qualify under Part 7. So I can't quite see. So, I mean, the other thing was the words in the beginning of the question were housing support or homeless support. So that got me thinking that they're saying you can only have supported accommodation or some sort of accommodation where people sort of check up on you, which you would be perfectly entitled to object to, subject to if you've got capacity. But the difficulty is if you won't consent to an assessment, I mean, looking at it another way, because the problem with this type of thing is agencies do get paralyzed and things get stuck. So I would say if the authority is saying you're not cooperating, they could say, well, we're going to make a decision that you're not entitled to be housed. We don't think you're homeless because we've tried to make inquiries and we haven't got any reason to be satisfied that you are homeless. But if there is a possession order, then they can't do that. So then they'd have to say, whether they think you're in priority need or intentionally homeless, and then it would come down to what is suitable accommodation for you. And so if you were saying, I want accommodation, and they're saying, well, you can only have supported accommodation, I think you'd be entitled to object to that if you could show that you didn't need it.
Or if they're saying that you can make a homeless application, but we won't help you if you don't engage with that assessment. Now, so the assessment's got covered, I think I've already said it, covered the three things. So why that person became homeless, what support they need to maintain housing, and what type of accommodation they need, or something like that. There's three things that needs to look at. Now, I would say that in this situation, you wouldn't necessarily, you could probably get that information from someone else. So that person might not want to go into a private interview room and talk to a rather abrupt housing officer to go through stuff that could be very personal. I don't know that the housing officer would necessarily need all that detail. They just need to be satisfied that section 193, for example, is met. So it seems like the situation, there's going to be obvious reason to be satisfied that person is in priority need through vulnerability arising from mental health issue. The possession proceedings would presumably give a lot of information that would say why that person, they're kind of, they are being evicted. You'd be able to get support or evidence from mental health professionals about, whether any of the exemptions about intentional homelessness would kick in. So, for example, if the person became homeless because of a temporary aberration caused by mental health issues, that's 9.17, the Code of Guidance, then they're not intentionally homeless. So I would say the council should be able to get a very long way in doing everything they need to do without that person sitting down and having an assessment. And again, I'm just thinking of a similar kind of thing within, it's really weird. So section 11 of the Care Act, basically, so for somebody who triggers the section 42 inquiries, but then doesn't want to engage with it, they still need to take place. And under section 11, I think it basically says professionals then need to get around, family members need to get around and say, they don't want to engage with this, but this is what we think they would say. And I almost wonder if there might be a similar principle in this situation where they might not want to do an assessment, but the council can still figure out everything they need to figure out through other means. I'm speculating, that's a punt, but yeah. So I think that
I'm struggling to see how, I'm not wishing to challenge because there's the assertion here that the person has capacity, but then it says that they're not engaging with anyone and they won't accept this is happening, which makes me think that whilst that's not definitive of capacity, it suggests that there may be capacity issues here because, and also that the person is perhaps, if they do have capacity, then perhaps they're being unreasonable, and it's difficult to be too critical of the local authority. But the other problem is if they don't engage and they don't sort of do it themselves, the way the system works is the council can say, okay, fine then, leave it, we won't do anything. Because if you don't complain or you don't challenge it, nothing happens.
I think what interesting in this case is to ask that person, what is it about this kind of process that you specifically don't want to engage with? Because it might be that they've been gate kept 100 times already. They've had 1,000 professionals involved in their life, none of whom did any good. And then might be like, I don't want to have my,
Yeah.
It might be that you can reassure them and say, look, actually, these are the questions you're going to get asked. Actually, they don't need to know anything about your mental health because we in this case, you'd think, okay, a person in this situation, even a housing officer could probably see that they're mentally not very well right now, and that would be that there's nothing that says they need to have a diagnosis. I remember working with someone in Bedford who we thought had Huntington. She hadn't had a test yet at that point, and the first housing officer says, "Oh, well, she's not had a test yet. She's not had diagnosed yet, so we can't help. We literally can't help." And then the second housing officer says, "Of course we can help. I don't need a diagnosis. I just need to be satisfied on the balance of probabilities that this person has Huntington's." In the same way, someone with mental health issues, you wouldn't. it may be they're not engaging with mental health services, but your housing officer can still see if someone's not very well. You know, I'd have thought that's within their, they don't need to diagnose them, but they can see that obviously there's something going on there. And that's, the Housing Act certainly allows a housing officer to kind of make that kind of judgment. You know, there's not, you know, they don't need to kind of get expert opinion or anything. It sometimes is obvious that someone's just not very well.
I think it was Bob Dylan who said you don't need a weatherman to know which way the wind blows.
Yeah. I think, and yeah, it's so housing officers are absolutely at liberty to kind of, you know, if I was a housing officer, and I know the good housing officers I know would really want to kind of, you know, get stuck in with this case and see what they could do, you know, and kind of have that multi-agency work, give that person lots of opportunities. It might be after a few months that, you know, just it's not working. It might be that they can accommodate that person under a power, if not a duty, whilst that stuff's happening. There's lots of stuff that the local authority could do if they, you know, if they wanted to house people and keep people off the streets. But yeah, I think, you know, people who don't want to engage will have a reason. There's a guy called Alfred Adler, who's a really cool guy. He's long dead now, but he was sort of followed Sigmund Freud, and he talked about this idea of private logic. And essentially, you know, people might look like they're making unwise decisions, but there's always a reason. There's a reason why they're doing something. It might not make sense to us, but it makes sense to them. And so, you know, if you don't understand what that reason is, then you're not going to get very far working with them. You know, you can try and kind of enforce stuff, but that's not going to lead to engagement, I'd have thought. Yeah. So, but yeah, as you say, was because they refuse to accept it's happening. That sounds like they've got, you know, they're really kind of, you know, lost touch with reality. And
they could just be very distressed, I suppose, about losing their home. They could be their family home that they've been living in for years, and you get sort of sucked into a sort of rabbit in a car headlight syndrome that you don't do anything. And I'm sorry if I suggested the person's being unreasonable when I have no right to say that, because I don't know the full story. And I hope it works out for them. Yeah.
So my, you know, when I went to Bedford Council, I was, you know, complex needs officer was my title. It was, you know, if you had the right professionals in the room with the right mentality, you could get good outcomes. You know, you almost always, you know, I can only think of one person who refused to engage out of you know, a lot of people. So yeah, hopefully you get lucky with the housing officer. Hopefully you get lucky with the social worker, because this, again, the Care Act would certainly kick in with this person. There's reason to think that this person might have care and support needs. Therefore, Section 9 of the Care Act has kicked in already, I'd have thought. Again, you know, if you get a good social worker and a good mental health worker, you can come up with some good options, I think.
Look, two things. One is I like the expression here that the person's used in the comment. The person has capacity, but not as we know it, which is I'll have to remember that one. And the other thing is, I guess everything's going to sort of come into sharper focus if the possession order is enforced and the person does become street homeless, and is then sort of at risk of suffering harm. And it then does start to become, it goes back to that interesting question, which we don't have time to deal with tonight in detail, but what do you do? I mean, you would literally have to section somebody, wouldn't you? If somebody with a severe physical or mental health problem is on the street and their life's at risk, and they're refusing to do anything, you'd have to sort of take them into hospital, even if because they were starting to suffer that harm. So I hope it doesn't come to that, but it's nice to know that you probably, well, I hate to say, you might get people thinking, oh, he's only lying on the street because he's been drinking too much, but usually people get picked up, don't they, if they're in a bad way?
Yeah, usually not. Yeah. Again, and there might, you know, I guess within this as well, it's probably data protection needs to be carefully considered. Data protection is amazing. If you roll your eyes at data protection, you haven't been taught about it properly. Data protection would make you think about this person, about, you know, their right to privacy, and balancing that, you know, and kind of and balancing that with other things that are going on. So in some situations, you would be able to process stuff against their wishes, in terms of sharing information with certain organisations, but you need to make sure it's been all done, you know, responsibly, and kind of where, you know, with the person's knowledge, if they're able to take that stuff in, because that, you know, data protection again would give the person control over who's involved. It might be they hate the council, it might be they hate an outreach worker or something, or whatever, data protection would give them the power to say, I don't want my data shared with that person. And that's a cool thing, you know. That means that actually, okay, that changes the frame that they're in a little bit. Maybe it might again help with engagement potentially. I've seen that happen before, where you just give person as much power as you possibly can get them, and that makes a difference. As much choice as you can get them, that can be a good thing. So yeah, just some of the comments there. So deprivation of liberty. I'm not quite DLOS.
Yeah, I think that's what that is.
MCA, mental capacity. Yeah, it kicks in. Yeah. Okay. Well, yeah. So we wish everyone luck with these difficult cases that people are involved in, and situations that people are involved in themselves. Keep the questions coming on the YouTube comments, guys. We'll call that a night. Thanks, Will, for your time. It's
Thank
really
you.
Cool. And yeah, thanks everyone for coming tonight. Keep questions coming. Basically,
see you next week, hopefully.
Yeah. Well, I'll talk about the meeting. So in fact, no. Will, are you around next Tuesday?
Yes,
I'm driving back from Somerset training next Thursday. I won't be able to make it, but if we so guys who are watching, just keep a lookout, because we might do it Tuesday next week rather than Thursday. So yeah, cool. All right.
Okay,